Hey folks, Dale Davidson here, Davidson Law Offices. Today the topic is estate planning. It's not just for the rich and famous, and it's just not for old folks. We're talking about you young couples out there, anybody over the age of 18 basically, okay? So let's kind of dive in. So estate planning is basically, it's built on a foundation. The initial foundation is your last will and testament. Now, as a newly married couple or a single individual, you say, well, I don't really have anything to speak of, or, but you probably have an automobile, right? You may have a house. You may have some other possessions. You may have a bank account, whatever it is. Those things, if something unfortunately happened to you, and guess what? Young people do pass away, unfortunately, way too early. We had one last week. But so you need to have a will that says, hey, if something happens to me, this is who I want to get my stuff. This is who I want to get my car. This is who I want to get my furniture, my bank account, whatever it may be. If you think that everything is going back to your mom and dad without going through some kind of probate, you're sadly mistaken. And probate, actually without a will, is called an administration. If you want to make sure that whoever's going to get your car is going to get your car, you need to write it down. Okay, it needs to be in a will. Who's going to get your bank account? Who's going to get the house? It's got to be in a will. For you husbands, newlyweds, or if you've been married for a while, husband and wife, if you don't have a will, guess what? Under the rules here in Georgia, your husband or your wife is not necessarily going to get all of your stuff, okay? Let's think for a second that maybe you're newlyweds and you have a baby. Who's going to be the guardian of your baby if something happens to both of you? Who's going to be the conservator of your baby if something happens to you? Both of you. So, see this stinking cute little boy? His name is LJ. He's my grandson. Okay? So I'm talking to you young couples. You see? He's young now, but I'll show you a picture. So, see, they grow up so quickly, okay? So you need to make sure that whoever is, if something happens to both of you, that your children are taken care of. So to talk it over, who's going to be the guardian and who's going to be the conservator. They don't have to be the same person, okay? You can have co-guardians and co-conservators, okay? A guardian is the person who has power over the person. So that guardian would determine, where your child lives, would determine personal things, as to their health and well-being, okay? The conservator would be in charge of all the money, the property, okay? And then the conservator would pay to the guardian money for the health and well-being of the child. So it's very, very important that you name somebody in a will. You can't just say, hey, I want my parents, or hey, I don't want this person, whatever. You got to be specific. If it's not in a will, guess what? It's not going to happen, okay? I have seen time and time again where a young couple passes, and then all of a sudden now we've got grandparents fighting. We've got aunts and uncles fighting. We don't want that. Okay, that's not good for the child or children in that case. So you and your husband, you and your wife, sit down and talk about who is going to be in charge of our children, both personally and money-wise, if something happens to us. Very, very important for you young couples. Moving on past the will, then we're talking about a durable power of attorney. Okay, so we have a durable power of attorney that says, if I can't take care of my financial business, then I've got my wife or my husband or my friend or whoever it may be to pay my bills. But as part of that, would you not want to possibly name a guardian of your children, a conservator of your children? If, God forbid, you and your spouse are in an accident and both of you are incapacitated, who's going to take care of them? You got to have some written instructions to that, okay? Very important. Make sure that you have written instructions as to who's going to take care of your children if one or both of you are incapacitated. Same way with the advance directive for health care. If you can't make your health care decisions, then you've got your spouse, your mom, dad, brother, sister, whoever it is, that's going to make these decisions for you. Okay? Likewise, if you're incapacitated, who's going to make those decisions for your children? Write it down. Let's get it on paper, black and white. Here, this is what I want. Okay? Because if you don't have it, guess what's going to happen? The state of Georgia is going to step in. Anybody want the state, the government, to tell you exactly what to do? No. So they'll tell you who's going to get your property, when they're going to get your property, how they're going to get your property, who's going to get your kids, who's going to be in charge, all of that. Your kids get everything when they're 18. Maybe they're not mature enough, okay? So in that case, maybe your will contains a trust. If something happens to my wife and me, then everything is held in trust for the benefit of the kids. And they'll get income and principal for their health maintenance, support, and education. They'll get some of it at 25, some at 30, some at 35. Whatever you desire. Okay, this is a blank picture that we can paint for you. It says, I don't want my kids to have everything at age 18. Maybe they have it all at 30 or 35 or whatever you want. But you got to put it in writing. Otherwise, the state of Georgia is going to tell you what to do. Likewise, if you don't have power of attorney, advance directive, we're going to have to march down to the, and you become incapacitated, we're going to have to march down to the probate court and say, Judge, Dale can't make his decisions. And oh, by the way, he has a minor child. His wife is deceased, so he's a minor child, and so what do? There's nobody there to make any decisions for Dale. Well, we've got to have a guardian, not only for Dale, but now we have to have a guardian for his child. And then, what about Dale's property? So we've got to have a conservator for Dale's property. Okay, so write it down. Very, very important. So estate planning, again, not just for the rich and famous. Estate planning is not just for the elderly. It's for anybody who's over the age of 18 to make sure that you determine who, when, and how people will be receiving your property. But if you've got children, more important, who and how, who's going to get your children and what's going to happen to their property. Okay, you decide. You have the power to decide today. It's not a very pleasant thing to think about, and young couples get in arguments. I don't want your brother, I don't want your sister, whatever it may be. But let's work through it because it's for the sole benefit of your children. Anyway, so I hope we've given you a lot to think about. You young couples out there, especially if you've got children, God bless you. Please send us some emails, comments, whatever, if you have any other questions regarding estate planning in general or any kind of particular planning, asset protection planning, whatever it may be. Do what's best for your children. Get out there, make sure you got a plan for them. Until next time, you be blessed. Thank you.
No more whiskey, I'll have a Coke. Catching bass on an old fishing boat. One more story from Grandpa Joe.